My Lord, can I call the case on?
Would you call the case on, and then I'll do the introductions after that.
Thank you, my Lord. This hearing is being recorded by HMCGS. You must not make any personal or private recording or publish any part of this hearing, including court communications. It is an offence to do so. In the Court of Appeal, before the Senior President of Tribunals, Lord Justice Baker and Lord Justice Lewis, in the matter of C1 2020-0447, Flynn versus the London Borough of Southwark and another, on Tuesday 16th of March 2021 at 10:31.
Thank you very much. Before counsel introduce themselves, let me just explain what we are doing and how we are doing it. Everyone here will be aware, and many of those watching will also be aware of the way in which the courts are proceeding during the COVID-19 pandemic to ensure that justice continues to be done in this period. This is a remote hearing conducted in accordance with the relevant protocol for the pandemic. It is accessible to the parties and their legal representatives and to a number of others who have indicated their desire to attend. It is also, I should add, being live streamed, so it will be reaching a much larger audience than those within the virtual courtroom itself. I hope those arrangements are working satisfactorily. If at any stage during the hearing they cease to work satisfactorily, we must rely on the individuals who are not receiving the hearing properly to make that known, at best I would think by email, if that is possible. We shall do our best to be alert, of course, throughout the hearing to any particular difficulties that arise. But we're now reasonably experienced, all of us, in the conduct of remote hearings, both judges and advocates and legal representatives, and I hope that things will run smoothly in the course of the next 2 days. At this stage, I think it would be sensible, Mr. Wolfe, if you would kindly introduce yourself and other counsel involved in the appeal, and then we'll consider some housekeeping matters once you've done that.
My Lord, I'm grateful. I hope you can hear me clearly. I appear, as you will have seen, with Sarah Sackman for Mr. Flynn, the appellant. Mr. Kalinsky appears on behalf of the London Borough of Southwark, the respondent. Mr. Harris, Mr. Whale and Ms. Kingsley appear on behalf of the interested party developer. Well, I think we have a cast of thousands in that regard.
Thank you. Well, I can see images of all counsel. I cannot see Ms. Kingsley on screen at the moment, but that may be simply because there's limited space on the screen. But thank you, Mr. Wolfe, for those introductions. Can I just deal first with, now Ms. Kingsley has appeared. Can I just deal with housekeeping matters? When Lord Justice Lewison granted permission to appeal, time was estimated at 2 days for the hearing of the appeal, and accordingly 2 days have been set aside for it. But can I ask whether counsel have discussed at least a broad split of time between you, so that we've got some idea of who's doing what when?
My Lord, if I can speak on that, we haven't discussed the broad split of time, but I'm optimistic in terms of the overall timetable. I don't envisage being, well, not necessarily even all the morning, and certainly not very much into this afternoon if I am all the morning. So I don't personally envisage we're any difficulties at all with a 2-day time estimate.
All right. Mr. Kalinsky?
My Lord, I certainly think we're comfortable with the time on that basis. I wouldn't exceed half a day for my submissions, and depending on how the case is put, if possible, it will be shorter.
Yes, I see. Mr. Harris, you'll obviously tailor your submissions according to Mr. Kalinsky's once they've been delivered. Good. Thank you. The next thing to say is that the court would wish you all to be aware that we have read the papers, we're familiar with the material before the court in the appeal, we've read the skeleton arguments, we've read the judgment in the court below, and concentrated also on the salient materials referred to in the skeleton arguments. So to that degree, you can assume that we are familiar with what you're going to be saying to us in the next day and a half. So I think nothing else, Mr. Wolf, at this stage, unless I've omitted to deal with anything. We shall break. If anyone feels the need for a break, because sometimes these hearings can impose additional strain that we're not all used to. If you do want to break in the middle of the morning, any of you, for any reason, would you please indicate that, and we'll accommodate that. Likewise in the middle of the afternoon. But otherwise, we'll aim just to press on and adjourn at normal time around 1 o'clock for the short adjournment. We'll rise today no later than 4:30. All right? Yes, Mr. Wolf.
My Lord, I'm very grateful. As you will have seen, and as you've indeed indicated, my Lord, this is an appeal brought by Commissioner Lord Justice Lewison against an order for Mr. Justice Dove, the 20th of December of 2019, and a judgment giving his reasons for that order of the same date. I will come in due course to his judgment, of course. The judicial review in relation to which that was all dealing was a judicial review, as you will have seen, of planning permission granted on the 10th of January of 2019. It was granted, as you'll see in due course, and perhaps I don't need to take you the documents on that, by Mr. Simon Bevan, the Director of Planning of the London Borough of Southwark, acting under delegated powers. And as you will have seen, there is obviously some significance of all of that. He granted that planning permission at the point, or in conjunction with the council executing a Section 106 agreement the same day. Again, we'll come to that. And subsequently, as you've seen, that Section 106 agreement has been subject to a relevant amendment by a deed of variation on the 9th of July of 2019. So we are concerned with the legal correctness of the judge's decision in relation to the planning permission in the context of that varied Section 106 agreement. My Lord, the judge set out the history of this in some detail, and I know, as you just indicated, the court has read all of that, but I will, if I may, just like to take you through that to some extent, and also to show you some of the underlying documents to which the judge referred and which you have in the bundles. I do that, if I may, to draw your attention to particular features on which we place certain reliance, and then having done that, having essentially told the history in chronological order, as I propose to do, unless the court wishes otherwise, I'll then deal with the grounds in a slightly different order to the order they appear in the skeleton argument, but essentially in the order of the skeleton argument. So, unless you or your colleagues indicate otherwise, that's my proposed course of action.
That's fine, thank you.
With that in mind, I've done my usual practice of removing the judgment from the bundle. And that will be my guiding note. I see that others may have done the same. You have it in core bundle number 1, tab A8, page 89. In his opening paragraphs, the judge tells the story in chronological order, and that's the way I'd like to do it. So page 90, Mr. Justice Dove introduced the planning application and the planning decision. I don't need to dwell too much on the detail of that. You have it in some detail. Except to see that, of course, this is a very substantial redevelopment scheme that's been a long time in the offing, that involves large areas of central London and will produce a number of significant changes. We don't shy away, of course, from any of that. What this claim and this appeal is, of course, concerned with is the way in which the planning authority dealt with the social housing requirements arising as they do under planning policy. That in turn arose because this mixed-use development, as you see in paragraph 1, it includes some 979 residential units. And that 979 and the way in which it is delivered, and in particular the affordable housing component of the way it's delivered, are at the heart of this matter. But what the judge set out, and I do just want to draw your attention to it briefly, is some of the relevant planning policy that was in play here. But all of this is, of course, referred to and was a key part of the planning authority's decision making, but you have it, I think the only place the court has it is set out in the judge's judgment. Within that, I don't need to stop on the National Planning Policy Framework materials you have at paragraph 4, but I would like to draw attention to paragraph 6 of the judgment, where the judge sets out paragraphs 3.10 and then later 3.12 of the London plan. This is the point at which we are introduced in this domain into the context of affordable housing. And we have here not only the overarching proposition of affordable housing, but also 3 subcomponents: social rented, affordable rented, and intermediate housing. And then over the page in the judgment, page 92, those 3 components are then further explained in the Mayor's plan. And we are particularly concerned, and the claimant appellant is particularly concerned, with the component of and the nature of the social rented housing element of all of that. You have then paragraph 8 running over the page 3.12 of the London plan. The judge quotes it, page 93, I'm sorry. And there are 2 aspects of it. The judge has helpfully underlined them, which I draw the court's attention. But first of all, 3.12 subparagraph capital A, which says this: for planning decisions and in LDF preparation, the maximum reasonable amount of affordable housing should be sought when negotiating on individual private residential and mixed-use schemes, having regard to, and then there's a range of considerations. What we draw attention to is, first of all, that it's not just the maximum reasonable amount, but it's also recognised to be a negotiation. This is not a cut and dry, it's not an exact science, it's not a quantifiable exercise, it's a negotiation between the planning authority and the developer. And then capital B, the foot of the quote, negotiations on site should take account of their individual circumstances, including development viability, the availability of public subsidy, the implications of phased development schemes, including provisions for reappraising the viability of schemes prior to implementation and other scheme requirements. And we, as you will have seen, are here concerned with pretty much all the elements of B. We are concerned with development viability, we're concerned with the availability of public subsidy, we're concerned with the implications of phasing or the reappraisement of viability. All of those are key parts of the argument here. We then have in paragraph 6 of the judgment an extract from the Southwark core strategy, part of its development plan for statutory purposes, and in particular Strategic Policy 6, which in large measure echoes, unsurprisingly, what you've seen in the London plan. SP6, in the quoted passage there: development should provide as much affordable housing as is reasonably possible while meeting the needs for other types of development and encouraging mixed communities. And then over the page, we will do this by requiring as much affordable housing on developments of 10 or more units as is financially viable. So again, that same balance to be struck. And as we see then, that then cross-refers to some saved policy from the previous Southwark plan. And this is where we get some very important figures, which you'll see are a theme of the Council's planning report and its planning decision. Saved policy 4.4 of the Southwark plan, so that's a minimum requirement for 35% affordable housing. We've seen what that covers, on the basis of a split of 50% social rented and 50% intermediate housing. And that is further seen in the text below that. That's the judge's paraphrase of it. That's further seen in the text below, where the reference is made to the Elephant and Castle opportunity area, which of course is the location with which we're concerned. And so in the table, we then see the split, the 50-50 split between social rented, an important term of art, and intermediate. And so 50-50 split, all within the context of an overall requirement of 35%. So the headline calculation would be to say we have several hundred houses, of which 35 homes, of which 979 homes, of which 35% should be affordable, of which 50% should be social rented. And that's the headline direction of travel, as you'll see in terms of the Council's analysis. In terms of the other policy we also have here mentioned at paragraph 11 is a policy called P4, which was part of the emerging plan, so not by this stage in any way part of the statutory development plan, dealing with a particular subtype of housing, private rented homes, so if you like, build to rent properties. And what we'll see when we come to the officer's report is that quite rightly, councils were advised that this was of limited weight because it's at this point only very much a draft policy. But as you see in the table on page 95, it would set, if adopted in the form currently contemplated, it would set an affordable homes target in relation to the private rented sector in a slightly different way to what we've seen in SP6. Still a 35% number as overall, but split in a different way, and introducing a new concept of social rent equivalent, which, as you see, and we'll see again, is a different proposition to social rent, and a slightly different aspiration, a 12% figure for that component within a slightly more nuanced split for this particular housing type within Southwark. But the point to underline here, and as I say, we'll see this in the officer report, is that this was of limited weight. Those are the words used in the officer's report. We then pick up the chronology of the matters in paragraph 12 of the judgment, and as it happens, this item came to the committee prior to 16th of January of 2018, but the judge picks up the story on the 16th of January of 2018. We take no point on that. On the 16th of January, an officer's report came to the planning committee in very much the overall form and structure of the report that we'll see in a moment that came back in July. The January report was tweaked to take account of developments in the meantime, unsurprisingly. So at this January 2018 meeting, members of the Defendant's Planning Committee had effectively all of the relevant information to deal with what was then on the table, and including what was then on the table in terms of the affordable housing proposition. And what you see is that at that stage, the proposal that was coming forward as part of the scheme was very significantly below the levels required by policy SP6, particularly in terms of the 10-year split. And there were two aspects to that failure. First of all, a numeric deficiency, but also, if we pick up the judge's words running over the page 95 to 96, no traditional social rented accommodation. So the amount of provision was very significantly lower in numbers, and I'll come to that in a moment, but also it was social rent equivalent rather than social rent. And so that takes us over to the top of page 96. And what we see in the second part of paragraph 12, even with that proposition, which we'll come to in the table in a moment, and what was being said at this point from the officers advising the committee, and this is 4 lines up to the bottom of paragraph 12, was that this offer represents, quote, the maximum reasonable affordable housing provision, taking account of various other matters. So in terms of the negotiation coming from 3.12 of the Mayor's policy and the analysis coming from SP6, even with this relatively much lower and in terms of type significantly different proposition, this was said to be the maximum affordable offer. I emphasise that because what you'll see is that even as the offer increases, and offer is the correct word I think in this context, that point is made again. So I emphasise that to disabuse the notion, as I've indicated already, that somehow affordability and the offer and the negotiation are a fixed, exact, predictable and black and white, binary edge, whatever way you want to put it, kind of concept.
So, can I just check one point? We keep saying that the assumption is that there's a major difference between social rent and social rent equivalent. Can you give us the definitions, or where to draw the inference that they're definitely different concepts?
Can I come back to that, my lord? I want to illustrate that as we go through, if I may, but by reference to the way in which the committee saw that, the officers advising the committee, and the committee saw that.
That's fine. There's nothing in the documents. I see some references to it in the documents that you refer to in the judge's judgment, but you haven't shown us a definition of socially rented or socially rented equivalent.
Well, the social rented definition, I think we've maybe jumped perhaps too quickly over social rented housing. There's a definition that you saw on page 92, top of page 92 in the Mayor's policy.
That defines it by reference to the criteria outlined in policy 310.
My Lord, yes, and the key overarching proposition that we see from that is that the properties are owned by local authorities or private registered providers, with rent set through a national rent regime. My Lord, you'll see reference to those, and in particular the ownership question and some of the things that flow from the ownership question in terms of the types of tenants who would qualify or be prioritised. As we come to the officer's report, you'll see for a moment, in a few minutes, I'll show you the way in which the officer's report dealt, for example, with the equalities implications of the proposals. This question of traditional, that's the word used, social rented properties was highlighted by reference in particular to the eligibility criteria that would be applied for particular types of...
Well, Mr. Wolf, it would help me if you could just summarise in a couple of sentences what the difference between the two concepts is.
Well, what we have in the Mayor's policy is that this is essentially local authority accommodation or registered social landlord accommodation with secure tenancies and rent fixed on a national basis with identified eligibility criteria for potential tenants of the properties, as opposed to social rent equivalent, which is essentially a much more amorphous concept, because it presupposes that the properties are owned by a developer or another private organisation, and then, in a sense, all bets are off on the things I've identified. So what we'll focus on when I come to the officer's report is the things which the committee focused on, or the officer's report advised the committee focused on, including, for example, eligibility, but you'll see there's more to it than that.
And they have a 3-year minimum tenancy with a break clause in favour of the tenant, as far as I can see from paragraph 11 of page 95. Just to get it clear in my mind, there will be some of the 35% of houses under this scheme which will be described as socially rented. But whom will they be owned by? Will they not be owned by the local authority or social provider under this scheme? Yes. Because if options 2 and 3 click in, they'll all pass to the council. So what is the concern about who owns the freehold of the land at the moment?
My Lord, can I come to that, if I may, in due course? I'm not in this instance ducking the question. I think just as a signpost to the answer, when we get to the implementation of all of this in the Section 106 agreement, which is where we're obviously moving towards, the issue arises in relation to those houses which are, or those accommodation units which are being provided pursuant to the review mechanism, the additional houses pursuant to the review mechanism, which are then to be implemented under the Section 106 agreement as social rent equivalent rather than social rent. So it's not the 116 that change their spots, if you like. It's the additional ones which arise in that contingency.
But my Lord's right, isn't it? In that contingency, they would be owned by the council under options 2 or 3.
You mean the property would be?
Yes.
Well, potentially so, but I don't think that's not in any sense pinned down. There's nothing in the framework which requires them then to be operated in the regime of social rented. The position is kept open.
Is there anywhere in the papers a direct contrast or comparison between social rented accommodation and social rented equivalent accommodation? Is that ever actually held up as an objective comparison anywhere in the papers?
I think the answer to that is no. The closest you get, my Lord, is in the written submissions that were made by the claimant and the interested party at the invitation of the judge, essentially, following the hearing. So you've got that, but that isn't, if you like, that's a tit for tat. It's not an agreed document. I'm sure if the court would be assisted, we could try and provide an agreed document.
Well, I only have in mind what no doubt we're coming to, which is the judge's observations about nuanced differences, I think, or some such expression. And I wanted to get hold of what the nuances were, if I could.
My Lord,
That was
absolutely.
what the speaker asked, and what you've said is that social rented equivalent is amorphous, owned by developers, but you haven't shown us anything that tells us what it is.
My Lord, you've got we're jumping ahead somewhat. You've got but I'm obviously entirely happy to do that. You've got the notes that were put in by the claimant and interested party in Core Bundle 1, Part B, tab 7 and 8. And they set out in some detail that the rent mechanisms, both in terms of setting rent and in terms of review and in terms of security of tenure. What I'll also show you, which wasn't in the note because it's in the officer's report, is the point that I made a moment ago, which is the issue around eligibility and the way in which the committee saw this. And in one sense, our overarching submission, we're very much jumping ahead, but I'm happy to signpost it, is that it was clearly seen by the officers drafting the report and by the committee members dealing with the report that the shift of type, and that's the word used in the report, from social rent equivalent to social rent was A, significant, and B, a significant benefit. And so in one sense, we say the difficulty here is, and the parties were in a sense complicit in this, was to get lost in the weeds of the detail of that, because that in the end is a planning merits question, which perhaps the court shouldn't have been invited or to look at in the first place, because the simple position here is that, as I say, and you'll see in a second, that the defendant authorities saw them as very different things, and indeed, as you'll also see in a second, the developer promoted, this is a very different thing, promoted, and entirely correctly promoted, its shift, as I was about to take you to, from social rent equivalent to social rent, as being a significant gain. But as I say, we're in terms of that particular element, the SR versus SRE debate, that essentially concerns the buy to sell uplift in the event that the developer exercises the fallback option in relation to the west side.
The word that I'm finding elusive at the moment is equivalent.
Right.
You're
right.
I'm finding elusive is equivalent. In what sense are they not different but equivalent?
I'm not sure that's a question to me.
Well, it's a question that I think the court would like your assistance with and your colleagues in due course. But not necessarily now. It may be that you want to reflect on.
Yes. I mean, in a sense, we would say that the word equivalent is not just elusive, but also not necessarily misleading, but incomplete. And the important thing, as I say, the proof of the pudding in one sense, is that the members and the officers of the defendant planning authority saw them as materially different and saw the shift, I should say again, the developer saw that and saw that shift as being a significant benefit for the scheme.
I suppose I didn't to understand how we can go on perceptions of what people thought. If there is a legal significant difference, there must surely be, in this context, a document that tells us what the characteristics are of a socially equivalent rented unit. You've shown us a document that tells us what socially rented is. It's a bit surprising to me that we're dealing with things that are said to be amorphous and said to be a perception as significant, and therefore it is significant. One should go back to basics and ask, where is the definition? Or at least, where is there a description?
I think the definition then for these purposes is what we end up with in the Section 106 agreement, which is a bit of a document trail. But I think as I indicate, the focus of the council, the members and the officers of the council in the process around the planning committee meeting and so on, was in seeing social renting as being a very specific and valuable proposition to A, achieve, and B, hang on to, and therefore not therefore diluting all of that. I mean, there's a number of issues set out in our note, which I just indicated to you. One of which is about who owns it. The other is about tenure. So as I indicated a moment ago, that social rented housing with either a local authority or a social rented social landlord is secure tenancies, with all that comes with that. Whereas SREs, as explained in this Section 106 agreement, are 3-year tenancies. Now,
what's the origin? What is the origin of social rent equivalent? Where does it all come from originally?
That's a good question. I don't think we have in the papers, but obviously we can dig into the provenance of the words SRE within emerging policy P4.
Is it a southern concept, or is it national concept, or where does it come from?
I would have to come back to you on that, my lord. It may be that others can assist. Now I can certainly assist later.
We also know that there's a concept called London Living Rent Equivalent, because that appears in the same table in the policy in the emerging plan. So my Lord's question as to the provenance of these concepts is one I think that we would all, three of us, like to see an answer to.
We will collectively do what we can.
I mean, Mr. Wolf, you've clearly identified a difference between the ownership, between it probably being owned by the council or registered provider and somebody else. But if it's equivalent, shouldn't it, as a matter of logic, common sense, be as, to all intents and purposes, the same?
Well, you might think so. You might think so, and I think that the word equivalent here is being used. It's one of those words that can obviously bear multiple meanings. It can either mean the same as, or it can mean essentially similar to. And I think it's being used in the context of similar to here, because clearly, absolutely clearly, what's being provided, what's being contemplated here, and SRE is not traditional SR. Not least because of the ownership question, the security of tenancy question, the rent setting mechanism issues, and so on, some of which are set out in our note. So equivalent, it may be that we're all grappling with the idea of how can it be different if it's said to be equivalent, but the simple proposition is it is different, and it seemed to be different, and was here seen to be different, and materially so by everybody involved.
Social renting has a much more clearly understood and defined definition, doesn't it? Is that right? Social renting. You told us all the features, tenure, etc., fixed rent, eligibility. Those provisions are clearly understood. Yes.
Indeed.
So we expect there to be similar clarity about equivalent, if indeed it is the concept that you're saying it is.
Yeah.
You're drawing the distinction, Mr. Wolf, and I'd like to know at some point what that is.
Well, I think I've given you some headlines of distinction. If that leads one to say, well, if those are the differences, how can it be equivalent? Well, then we say that's part of the problem, that's not our problem in a sense.
All right. Well, it's not a question of whose problem it is. It's just a question of helping the court at some stage, not now. So I think having flagged this concern or question, might I suggest that we move on for the time being, Mr. Wolf, and then we'll come back to this.
Of course. I was on page 96, the end of paragraph 12 of the judgment.
Yeah.
What the judge sets out there, and I won't grind you through it, is what happened at the 16th of January meeting, which was essentially that the matter was deferred because of in a sense, a minded to refuse position. And a second meeting was scheduled for the 30th of January, at which the relevant agenda item was the discussion of the reasons for refusal, as they would have been. In that context, you have two letters I would like to just look at, if I may. Yeah. These are both in the supplementary bundle, in a tab at the beginning of the supplementary bundle, tab 1. And you see tab 1, page 3, if I may, is a letter of the 15th of January. So that this was just ahead, as you see at the foot of page 3, of Tuesday's planning committee meeting, and that's set out in tables over the page, which you'll then see elsewhere in a moment. The then affordable housing mix that was on the table, and if you just look at the two tables on page 4, you see what had been the proposal previously and what was now said to be the updated affordable housing offer. And just looking at the updated affordable housing offer in the lower part of the table, the second column is headed social rent equivalent, and that has a total unit number, if we drop to the bottom of the column, of 33. So that was then the proposal, was 33 social rent equivalent. Over the page then, in that same letter, the letter from the developer's agents, there's a list of bullet points describing the key components of the affordable housing, updated affordable housing offer. Second to last bullet point says this: should grant funding become available, the updated affordable housing offer may be further improved with additional London living rented homes converted from DMR homes. That's the first point at which we see in the papers, I think, reference to the possibility of and potential implications of grant funding, and the way in which grant funding could enable an improved offer. The second document, which comes after the 30th of January meeting, but it's convenient to look at it here because it's in this same tab, is page 11. And what you saw from the judge's account of the meeting on the 30th of January is that meeting was itself, I don't use this in a rude sense, derailed because further proposals came from the interested party. So rather than have a meeting to formulate reasons for refusal, essentially based on social housing issues, the meeting was adjourned to allow consideration of the last minute further offer which had come, which you have on page SB 1, page 11. That page 11, lower half of the table, sets out the affordable housing offer to be looked at on the 16th of January. So that's the one with social rent equivalent and 33 as the unit mix. And then over the page, we're reminded that even that offer was thought to be the maximum reasonable in planning terms, and then we then have an updated affordable housing offer. And here, this is table 2 on page 12. That column now becomes social rent rather than social rent equivalent, and the unit mix, total unit mix number is now 74. So we've gone from 33 to 74, and social rent equivalent to social rent. And you see in the bullet points below the table, second bullet point, the provision of 74 social rented units to be located on plots W1 and W2 of the western part of the west side. This replaces the 33 social rent equivalent units included in the agreed affordable housing offer. The 74 social rented units will be owned and operated by either LB Southwark or a registered provider. So that's was specifically trailed as being the change, not merely the change of number, but also the change of type, with particular emphasis on the ownership question. That derails what would otherwise have been the discussion on the 30th of January. There's then yet with further developments between then and the matter coming back to the committee in July. You see that the judge picks this up in paragraph 15 of his judgment. But before I get to that document, that date, if I could ask you to look at page 25 of the of SB1. This is a June document, but we don't have the date within June on it. Coming again from the interested parties team. So this is described as an affordable housing viability review, and within that, at page 28, if I may, what you will have seen is that one of the issues which emerges is what happens in the event, and indeed my Lord Justice Lewis asked me about it initially just a few moments ago, of not substantial completion in the timescales. That's because the affordable housing is on the west side, and the west side's going second. And paragraph 7, it is the provenance, I think, of the suggestion which emerges into the officer's report about how that situation will be dealt with. And we see it coming from the developer's side. In the event that development on the west side has not been substantially completed within 10 years following the grant of planning permissions, the owner shall transfer to the council or a registered provider the long leasehold interest in the land age read on the plan attached, and pay to the council or registered provider as appropriate the sum of, to be inserted, for the purpose of construction and completion of the west side social rented units. The proposal, which you'll see in a moment, emerges as a stipulation, that's the word used, within the officer's report, has in fact come from the developer's side of being their proposal in terms at least of the overall structure of it.
Do we know if this was an internal document for the interested party, or was it something that went to the council officers, or was it something that went to the councillors at the meeting? It said to be a file note.
I think the answer to that question is that it's gone to the officers at the council, but I don't think, I'll be correct if I'm wrong, at some point, that it's part of the materials that were seen by councillors.
Thank you.
But we then have paragraph 15 of the judge's judgment, or alternatively, the letter itself is on page 29 of the supplementary bundle. So this is in the period heading towards the committee meeting, where again the developers, this time planning consultants, write to the council, and in a third paragraph say this: discussions with the GLA have progressed positively since February 2018. And we are pleased to confirm in-principle agreement from the GLA to provide grant funding towards the proposed scheme. As evidenced by the enclosed GLA letter dated 14th of June, the applicant's affiliated company is eligible to become an investment partner. So we have two separate propositions there. We have in-principle agreement and then a letter explaining that we're eligible to apply for grant funding. And then in the next paragraph, the grant funding enables the delivery of a further 42 social rent homes on the west side, plot W3 Building 3, which means that 116 social rent homes are now proposed in total. It's envisaged that these will be owned and managed by Southwark Council, and then there's more detail. So the very clear thrust of that is that we have in-principle agreement from the GLA on grant funding, and that grant funding enables us to increase our offer from 76 to 116. That's the link we get there. With that letter, as it's indicated, are some other documents. I just want to show you, they largely repeat what you've seen elsewhere, but one of those documents is Appendix 3 to that letter, which is page 34 and then into 35 of the same bundle. And that 35 may be slightly hard to read because it's printed very small. It is a specific addressing by the developer of what are said to be the reasons for refusal as reported to the Planning Committee 30th of January. And so what we see in the columns is member reason, left-hand side, number 1, affordable housing. You see that the draft proposed reason for refusal as it was being contemplated but never got decided upon at that meeting. And then right-hand column, applicant response. The applicant has maintained the offer of 35% for affordable housing, but re-provisioned the tenure splits. This means that the number of social rented homes increases from 33 to 116, assisted by securing grant funding from the GLA. The intention has been to provide larger family units for the social rented schemes, and the social rented homes will now be owned and managed by Southwark Council or a registered provider. So again,
the question is, what is the status of this document? It's interesting to see it, but did it go to the officers? Did it go to the councillors? It's Appendix 3, and I take it as an appendix to an earlier letter. But to whom was it sent? Because we're looking at what was in the report and what the councillors decided.
I think I completely understand that, but I'm very keen to do that. I think what we have is that the 15th of June letter. This is an appendix to the 15th of June letter, which we had on page 29. which was part of the materials seen by the council. It's not presented to the court in that way, but it's part of the materials seen by the councillors.
So the councillors did see this.
So the councillors saw the appendix 3.
Indeed.
Can I just indicate, I'm not sure that there's evidence to that effect, and I don't think that's accepted. I don't want to interrupt, but I just don't want the argument to proceed on an incorrect basis. Is it helpful if I indicate my understanding of the position if the court's concerned about this point?
Yes, please. I think we do need to know whether that was before the councillors.
So I specifically asked about this, and the instructions I've got is that if you look at page 35, in a sense, this is a response document prepared by the developer. That precise document was not before members in July. The original document, in other words, a schedule containing the officer's analysis of putative reasons for refusal and the extent to which any risk arose from them, was a document that went to members in the 30th of January meeting, because obviously they were thinking about whether there was sustainable grounds for refusing. So this particular variant of the table did not go to members. It was simply to officers in July, but the table absent the last column would have gone to members on the 30th of January because it was the very business that was presented to them. So I hope that's a fair way of indicating my understanding of the position.
Well, I apologise if I've got that wrong. Our understanding, and I'll check why it was our understanding when I get a moment, was that the 15th of June letter with its appendices was part of the pack for members. But if that's wrong, it's wrong. So we'll certainly check that.
Can we get any clue from the minutes? Page 260.
I'm not sure that we do.
I'm not saying we do. I was just.
I think that the way we pieced this together, possibly rightly or wrongly, we'll come back to it, of course, was on the basis of the pack, the downloadable pack of materials that were before the members, because they
Yeah.
but as I say, obviously if we're
Members
wrong.
pack. I'm looking at the top of page 261. The Chair gave notice of the following additional papers which have been circulated at the meeting. Bullet 3, members pack relating to items 6.1, 6.2 and 6.3.
Well, absolutely. If there's an issue, we'll obviously check it. I'm sure Mr. Kalinsky will check it too.
Thank you.
So that's the position going into the council meeting. You then have the report to the planning committee, which is in the same supplementary bundle. That starts in tab 2, starting at page 47, including obviously a fairly familiar style of introduction on page 47, and then, as is often the case with reports like this, a recommendation. And the recommendation, paragraph number 1, little a, was that planning permission be granted subject to conditions and the applicant entering into an appropriate legal agreement, ... There's other things with which we're not directly concerned. So that was the recommendation that in the end the members accepted. There's a bit of history on page 48. So one of the slightly confusing things about this document, just to jump to paragraph 5 for a moment, is that in paragraph 5, it tells us that the officer report remains largely as the earlier report. That's the January. The February report, but has been updated accordingly, and where substantive new text has been added, this has been italicised. So there are passages in this document which are italicised, but they're not the only changes. I don't take a point on that, and I'm not going to draw any particular distinction between the two, but it's not quite as simple as saying old is in standard font, new is in italics. What's in italics is definitely new, and what's in standard font may or may not be, and you somehow, to some extent, have to work it out in the context. But paragraph 2 to 4, though, tell us that the history, In particular, paragraph 2 tells us about the deferral in January, and then paragraph 3 tells us that the 30th of January meeting was derailed by the arrival of the new offer. Line 6 in that paragraph says this: this submission was not a formal amendment to the application, but did seek to address the key concerns discussed at the meeting on 16th of January, mainly the amount of social rented units, ... So that was the key concern which derailed us at that point. Within that same page, dropping down, I've shown you the reference to italicized text, and that paragraph 5, also explains what are called the main changes. The main change the applicant has made to the application since it was presented to the Planning Committee on the 16th of January are as follows. And then the first item, affordable housing. A revised affordable housing offer has been submitted, which increases the number of social rented units in the development and provides them as traditional social rented units which could be owned by the council or a registered provider, as opposed to registered social equivalent units retained by the developer. So right up front, the council is promoting the fact that the increased number is not just an increased number, it's a change of type. Now, just to be clear and pick up the point that the Lord Justice Lewis asked me about, there's no suggestion in our case or in these arguments that the 116 would be somehow delivered as social rent equivalent. That's not part of the suggestion. So when we come to looking at what I was asked about before, namely options 1, 2, and 3, and so on, that discussion doesn't engage the question of social rented versus social rent equivalent. That the discussion around
the alleged 15 extra units in the event they do the bill and serve.
Exactly right.
So exactly right. The split. So we're looking at the split of that extra 15, whether it'll be what 7 or 8 socially rented rather than socially rented equivalent versus whatever the others have got to be. That's what you're complaining about, is it?
Not quite, but we're nearly there. So the 15 is the cap which is put in the Section 106 agreement on the number of whatever it is, SR or SRE, that would be delivered in the event that the developer elects the buy-to-sell fallback option. So it's not that the 15 is split between one thing and another, it's that a maximum of 15 additional units would be offered, and there's an issue about the number, and that's one of our grounds of challenge.
I understand that, that's why I said alleged. What is the argument that these 15 are going to be socially rented equivalent rather than socially rented? Is that the argument?
Exactly right, my lord, exactly right, my lord. So the concern isn't about...
I'm sorry to intervene before, and apologies to Mr. Wolf. We're talking about 15 habitable rooms.
Sorry,
and that is a much smaller number of units.
Right, yes.
But I didn't want that to become entrenched as a 15
No,
unit.
it was entrenched. It's just as well you stopped me thinking that there's 15 habitable rooms, and the question is those 15 habitable rooms will be socially rented equivalent, which is as yet undefined, rather than socially rented, where we've seen a definition. Is that where I've got at the moment, Mr. Wolf?
You're exactly in the right place. I'm grateful to Mr. Harris for picking up on that gloss.
While we're pausing, I'm sorry, Mr. Wolf, forgive me, but while we're pausing in the flow, we come back to the committee report at 5.1, page 48, and look at the way that it's put there, which gives the counterpoint, if you will, between traditional social rented units, which could be owned by the council or a registered provider, as opposed to social rent equivalent units retained by the developer. Does that isolate at least one distinction between the two concepts?
Absolutely, Minister. I heard what I said earlier on. Yes.
And is that really the beginning and end of the distinction, or is it just one of the points? It's
just one of the points. In headline terms, without wishing to sort of spend too long on it, security of tenure is another key headline aspect, because properties with a registered social landlord or the council would be secure tenancies in the statutory sense, which come with all the or the statutory protections that arise from that, whereas the SREs are not. They don't have those statutory protections. And then you'll see in a moment, and indeed it's almost the next thing I'm going to go to.
What protections do they have? We're seeing lots of references. This is why they're using the word equivalent. We all understand equivalent is not identical, but it is said, and is trying to penetrate the details, that in fact they're going to be granted on long leases. I've seen a reference to 3 years with a break clause for the tenant only, and I've seen references to perpetuity. So it really would be helpful to understand the facts rather than a party's gloss on the facts, if you understand me.
Well, my lord, absolutely, but sorry if this is repetitious, as you're beginning to see, the developer and the local authority and the councillors saw the distinction as being significant. And in one sense, we say it's not for the court, we would say, obviously with enormous deference, to then go behind that, because that's a matter of planning judgment. It's a matter of planning judgment as to whether that was a material distinction for the purposes of members supporting this scheme. And what you've seen to some extent, and you'll see more of it in a moment, is the way that was being presented by the developer and by officers to councillors entirely properly as being the shift in the 116, not talking about the additional ones for the moment, the shift in the 116 or the uplift to 116 and then the shift in type was seen as being in my words, material benefit, material distinction.
Yeah, well, so far all you've shown us is that it records as a fact that there is this difference, so we can leave it there and move on.
Well, look, I'll come to more in a moment, if I may. In terms of the background, you may not need the location elements, but you have at page 51 information about the site location and the description of it, and in particular, so it divides the east site into components, and then the west site into components, and the west site section starts on page 56. And the relevant part for our purposes is plot W3 on page 57. So as it happens, the components of affordable housing have moved around in the scheme. We're not concerned with that detail, but the relevant information is, the relevant, I think, for our purposes is that they are part of the west site, which is the second phase, and that's the concept, that's the context in which the mechanisms around securing delivery of social rented housing was in play. The point I was going to mention before, which I now take you to, if I may, is within the Equalities implications section of the report. That section starts on page 83, just so you understand the hierarchy of headings. Unfortunately, the heading has appeared at the very foot of the page on page 83. Within that, there's reference on 84, as you'd hope, paragraph 157, to the legal context and reference to the public sector equality duty, and then the subsequent paragraphs are the council's analysis in a line by line, sort of topic by topic way of the equality impacts as being viewed through the prism of the public sector equality duty. It's quite a long section, and it picks up on page 98, paragraph 231. But the reason I take it to the beginning is that it's all part of the evaluation of those elements. And on page 231, there's a heading affordable housing. So this is affordable housing as an equalities issue. Paragraph 231, concerns have been raised by the Southwark Law Centre and the Elephant Amenity Network that the type of affordable housing proposed, by excluding people who are economically inactive, would have adverse equality impacts, as this could disproportionately impact, for example, on people with disabilities or who are older. And then the italicized section, the updated affordable housing offer now includes traditional social rented accommodation, which will be owned and managed by the council or a registered social provider, as opposed to social rent equivalents, which would have been owned by the developer. Nominations would be from the council's housing list in the usual way, which does not exclude economically inactive people. So a very specific benefit is identified arising from the linked to the ownership question, which is seen as a public sector equality duty implication as part of the analysis here.
Mr. Wolf,
And this will remain the case with 116, as I understand it. It's only if there's the sell and buyback, selling to the private sector and the 15 extra homes. It's only the 15 extra homes that's the difference from this, or have I not understood it?
You've completely understood that. Subject to it being habitable rooms, as Mr. Harris rightly.
I'm assuming the 15 is correct at the moment. You're going to say it's wrong, but it's only the extra rooms on the build and sell to the private sector that arises. So there's nothing in this that's wrong. Your point is simply if it's that important for the 116, it should be equally as important for the 15, or whatever the number.
That's a good way of putting it, my lord. But I'll come back to it if I may. And it's not me saying that. It's that when the councillors, and the reason I hesitate, that's not merely my proposition. It's that when the councillors deal with the what should happen in the event that the developer elects the buy to sell option on the west side, they are talking about more social rented housing, and so it's more of the same, and the same having these various benefits that we're looking at. But also the next section, the section that substantially deals with affordable housing, it starts on page 124. So again, the headings are the bold text rather than the underlined text. So affordable housing heading on page 124, and this whole section then is dealing with affordable housing. And quite properly, the report takes members through the various planning policies, including 350 reference to the London Plan and paragraphs, the policy, 310 and 312 of that. So the bottom of paragraph 350 quotes, or paraphrases, the policy 312, reminding members of the process, effectively, of negotiation leading to a maximum reasonable amount. And then 351 explains the proposal. The proposal is primarily for a build-to-rent development with the private rented sector, PRS, albeit with traditional social rented units and a fallback option to deliver conventional build-to-sell units on the west side. These latter two elements are changes to the applicant's proposal since the scheme was presented to the Planning Committee on 16th of January. The affordable housing proposal is described in detail below. So again, identifying the changes, not just a change to social rented units, but also the introduction of the buy-to-sell fallback option, which we've been mentioning. Over the page on page 125, members are told quite properly at 354 of the core strategy policy SP6, and paraphrased quite properly there, you've now seen the policy that the judge included in the judgment, quite properly explaining there that the SP6 requirement would be for 35% affordable housing, and then within the Elephant and Castle Opportunity Area, the split between the split would be on the basis of 50-50 intermediate and social rented. So that's the 50-50 proposition that we're dealing with, and I just pause to say there that is the kicking off point for discussion around a 50-50 split. The 50-50 split comes from, or is only coming from, core strategy policy SP6, as it's here being applied to the entirety of the site. 355 and 356 then introduce new policy P4, and you've seen the background to that. But the point I indicated much earlier in my submissions, paragraph 357 then quite properly says to members, this policy is a material consideration, though currently it has limited weight. Now, of course, that's a perfectly correct statement of the legal position, given the statutory obligations in play here. But then again, heading's been separated from its text. On the 125 is the heading affordable housing proposal, and that is then set out paragraphs 360 and following, explaining 360 introductory section about the wider development. Alongside a new shopping centre, a new education campus and other units, the site proposes a number of residential towers and blocks which provide a total of 979 residential units. The development as proposed will be primarily PRS, primarily rented sector, also known as build-to-rent product, but with traditional social rented units provided on the west side, as opposed to the previous offer, which was for social rent equivalent units, as envisioned in draft policy P4. So again, clear distinction is being drawn and benefit being placed upon the fact that the offer has now switched from SRE to SR. And of course, mindful of my Lord Justice Lewis's point, this is about the proposition of what's being provided generally, including therefore the 116, and we see that 361 and 362. That is then tabulated, or part of that is then tabulated, and we see, without going through the whole detail of it, the way in which that then breaks down to be 330 proposed units of affordable housing, of which 116 units of social rent within the overall total. And what matters then in 363 is the conclusion that's drawn from that by the officers. Says this: whilst the proposal would comply with a policy requirement to provide a minimum of 35% affordable housing by habitable room, the above demonstrates it would not comply with the adopted core strategy policy, which requires the affordable housing to be a 50-50 split between social rented and intermediate units. So we're up to the 35% affordable housing, but with the wrong split. And it would also not comply with emerging policy P4, and then it explains why that is. And then we get a couple of paragraphs which are very, very important to all of that. 364, so an italicized passage, I'm sorry. The affordable housing proposed would also not be evenly distributed across both sites, with the social rented units all being delivered on the west side. So that's the second in time. The Section 106 agreement would therefore stipulate that if development on the west side has not substantially commenced within 10 years of the east side commencing, the land and sum of money sufficient for construction and completion of the social rented units will be transferred to the council to deliver the social rented units. And obviously a key issue in the case is what the court makes of that paragraph and what legal status and effect it has. And I'll come back to that obviously in due course. And then there's a heading fallback position, which we've heard a bit about. Fallback position: the applicant also wishes to retain a fallback position whereby the west side could be delivered as traditional build-to-sell units. The exception to this will be the social rented units in the mention blocks, which will be delivered in any event. So in other words, the 116 that we've been talking about would be delivered in any event. That's there in the bank, as it were. The developer would notify the council of the intention to develop the west side as build-to-sell, and the affordable housing requirement for this, in other words, the new proposal, would be for 50% social rented and 50% intermediate. Some of the west side social rented units would already be secured in the mansion blocks, albeit 38% rather than the 50% requirement. Therefore, a review mechanism would be required. So what's contemplated, and you'll see in a moment how this works, in the context of the overall viability review processes, is a particular component to deal with a situation in which the developer elects this very specific fallback position. And what the paragraph specifies is that the housing requirement would be 50% social rented and 50% intermediate. So in other words, tracking back to the SP6 requirement. In other words, this gives us an opportunity, my paraphrase, this gives us, the council, an opportunity to seek to secure the policy compliant 50-50 split, which at present, we're being advised, can't be secured for viability reasons. So that's essentially what we are told, we the members are told by our officers, as is going to be the position in the event of the buy-to-sell position. And that is the kicking off point, the point my Lord Justice Lewis has been asking me about, which ends up being 15 habitable room equivalent as a capped figure, rather than, we say, the 50-50 split which is contemplated by this paragraph. So again, of course, in terms of the overarching legal analysis, fundamental to the case, one way or another, is what the court makes of what is said in these paragraphs as part of the committee's deliberations and as informing their decision. What is the legal status and role of passages like this in this report expressed in the way that they are? Still in the same section, paragraph 371, there's a little bit more analysis.
If you look at 367, which is one of the things that's discussing here, as I understand it, it says all affordable housing, that is social rented or social rented equivalent would be provided in perpetuity. There is no doubt, is there, that the 15 rooms can't be taken back by the developer and sold for market profit. The 15 habitable rooms, whether it's social rent or social rented equivalent, will in perpetuity be used for those purposes.
Absolutely, my lord. There's no issue
Right.
with that at all.
Right.
It's not any part of our case that that quantum and that type, whatever the quantum and type turn out to be, in the event that the buy to sell option is chosen by the developer, are long-term imperiled in that way. There's no issue about that. The issue is about.
So your concern then is that if it had been social rented, an individual tenant would have whatever is called in landlord and tenant terms, secured assured short-term tenancy or something. But in the 15 rooms, it'll be a 3-year lease with a tenant break clause. But after 3 years, something has got to happen because the landlord can't take it back and say, well, you've had it for 3 years now. You go on the streets. We're going to sell it for a profit. It would have to go to somebody else who meets the eligible criteria for social housing, presumably.
Yeah, that's right. That's right. But security of tenure for and I don't mean to use this word in any patronising sense, the vulnerable people who are prioritised by the council's social registers, social housing registers. Security of tenure is a very important and significant component of the housing offer that comes to them from.
I understand that. I really do understand that for the individual tenant, if it's your home, the terms on which you own your home or live in your own home are critical. But if you stand back, and that's what I'm trying to understand, and I'm not making points, I'm trying to understand. If you stand back, we do know that these 15 homes will always be available for someone who meets the social housing criteria.
Right. 15 rooms.
50 rooms, yeah.
But as we've seen, I don't want to go back to it unless we need to, it's meet the criteria, but potentially different criteria. And that was one of the specific benefits that the council, it was in the equality section, I'll go back to it if we need to. The council identified a specific benefit from the eligibility criteria, and that certain components, certain, try again, avoid pejorative language, certain groups of people would be eligible for registered social housing who wouldn't necessarily be eligible for the social rent equivalent product. So
who decides who would get the new, say that the 3 years come to an end, or say that the tenant exercises the break clause, who decides who gets the next 3 years? The council or the developer?
I hesitate to trespass where I'm not confident, but I think the answer is the developer, because under this scheme they would be owned by the developer. But so I think that must be the right answer. But we'll come back to that if needs.
And do they have to give it according to criteria fixed by the council then?
I'm sorry, Lord.
Does it have to be according to criteria fixed by the council?
Can I come back on that specific point? I simply don't know the answer to that, my lord.
I wonder whether some of the answers to my lord's questions might be revealed if we looked at the Affordable Housing Statement Addendum of July 2017, which was referred to in paragraph 367, because that may give flesh to the bones of in perpetuity.
Lord, that's right. And also, just to answer Lord Justice Lewis's point, if you go to 432 in the main bundle, there's a definition of social rent equivalent, page 38.
432.
Yes, 432. Again, I'm sorry to interrupt.
Yeah, but well, while we're paused, let's do that. 4322. That's volume 2. Is it?
Page 38 internal. And there's a lot more to be said about this, but it just directly answers the Lord's question in relation to nomination rights, etc.
Sorry, did you say 438?
It's 432, page 38 internal, Lord.
Sorry, big one. 432, yeah. Thank you.
Can I just raise one question? I don't think it's answered in these definition sections Mr. Harris has drawn our attention to. Is it possible for housing that is owned and let by a local authority to come under the category of social rent equivalent? Or if the property is let and owned and let by the local authority, does it have to comply with the national guidelines, which would turn it automatically into social rent housing?
I think the answer is the latter, my lord. I think is right. So if it's presented as being social rented housing,
so in that, if you, I may have
my hesitation, I'm not sure that
those circumstances. The key question is ownership. Who owns and lets the property? If it's owned and let by the council, then it becomes social rented housing.
Well, I don't think it necessarily does. That's my hesitation. I would need to check whether a council, independently of the section of social rented housing, can have, and I suspect the answer is it can have, whatever other form of relationship it wants.
Is it really this, that what the obligation achieves, it is suggested, is effective equivalence between social rented accommodation properly so described and understood, and social rent equivalent accommodation in the hands of the landowner, developer, which is nevertheless constrained in the ways indicated in the definition to which Mr. Harris has just pointed us, so that it transfers, if you like, equivalent obligation to the landlord if the landlord is the developer. Is that how it works?
My lord, to some extent, but that's where I draw your attention back to the exchange of notes that you have in tabs 7 and 8 of section B in core bundle 1.
Yeah.
Where as it were, building on what ended up in a section 106 agreement, which was sort of contractual constraining of all of this, we have analysed, and Mr. Harris's clients have analysed the various elements that are set out there: rent levels, security of tenure, and so on. So that's where the social rent equivalent ethereal concept, and I'm helpfully told by Ms. Sackman that she's had a look in the meantime, and we'll come back to this in due course. What the Southwark plan, emerging Southwark plan, says about policy P4 and SRE, which you saw there as part of the P4 definition. Apparently, there's nothing in there that sheds any light on this question, but obviously we'll come back to that.
No, well, I mean, social rent equivalent, whatever it may mean in a general way, means this specifically in this case. See page 432, as I understand it. That is what we're dealing with.
That's right. And then the exchange of notes at tab 7 and 8 unpack, if that's the right word, what that means in terms of security of tenure and rental.
I have to look at submissions at 7 and 8, but it seems to me that in some ways you're talking about two different things. You're talking, and I understand why, about what it means for the person who's living in the unit. Will they have security of tenure or not? If you look at it from a different end, the council, they are looking at, will that unit be used for people who need social housing or not? And as far as 432 is concerned, it looks as if it's people on their protocol list for social rented units who will get it. Now, I do understand that means that the tenure would be different, and I do understand that person may not get it forever. But in terms of whether or not this is materially the same as if it were owned by the council, so far as who is going to be there forever, the answer is it'll be the same, because it'll be people who are social rented eligible people. May not be the same individual, I understand that, because it's not the right tenancy. But from the council's perspective, the unit will be for people who are on their protocol for social rented units. Is that a correct way to analyse it? It depends on which way you look at it.
I don't think one can as it were, take off the perspective of the tenant and disaggregate that from the council's perspective. Because, of course, the council, in a strategic sense, it's concerned about maintaining the in perpetuity bit, the number of whatever it is, and them not then being subsequently sold into the private market. That's obviously a strategic concern for the council. But the council is also concerned about the tenure from the point of view of the tenants. These are not abstract people. These are people for whom the council has responsibility. And if those people see it differently, and it's not just a perception thing, they have different legal rights. For some of the most vulnerable people in the community, that is a matter about which the council is concerned, and that's in part why the officers' report and the other materials emphasise, no doubt, the benefit of traditional social renters. It's not from the council's point of view an equivalent, and we say that's.
Isn't that the question for us, whether the council, when it delegated, was looking at it from the point of view of delegation at the overall picture, or whether they were saying the delegation means you can only enter into an agreement if it actually has for individual tenants the same thing? You've rather assumed all of that, and I think that might be the question that we've got to grapple with, which is why I spent some time trying to work out what these phrases actually mean and where they come from.
It's certainly one of the questions that the court has to grapple with, and in a sense, the SR versus SRE analysis, important as it is for precisely the reason that my Lord Justice Lewis and I have been canvassing. It's not down the pecking order, but it's a subsequent stage of the analysis, and it concerns a relatively smaller number of properties. And the kicking off point, and my Lord is right, obviously, and indeed it's our case, that the issue that we're dealing with is what the councillors delegated to the council officers, arising from paragraph 365, and the place I was going to go to shortly, which we'll come to, which is 404, and so on. But that's absolutely right. That's the question for the court: is what was the scope of delegation for council officers in relation to negotiation section 106 on a number of things, of which this is one. That's clearly the key thing. And obviously, if the court takes the view that that was within the scope of their delegation on that point, then the tenant is on that point.
Putting some interference, just pause for a second. At the risk of being very tedious, Mr. Wolf, whether it's convenient now or later is for you. I would quite like to be looking at the Affordable Housing Statement Addendum of July 2017 to see whether it helps us understand the concept of in perpetuity as used in paragraph 367 of the officer's report. It may be that comes later in your submissions, but can I just leave it on the list for you?
We'll certainly come back to that document. I think we might have to provide it to you separately. It's not any part of our case that there's an issue around the in perpetuity of the overall quantum of additional rooms in the way that my Lord Justice Lewis has been putting it to us.
No, I was simply wanting to see whether the concept went further than time.
I see.
And had a different dimension as well. It was simply that which does connect to the conversation we've just been having.
Of course, we'll come back to that. But my Lord, it's not part of my case, but I'm obviously happy to deal with it when we will.
That's fine. I don't want to take you out of your flow now.
No. My Lord, the other paragraph, the next paragraph I need to take you to, over the page at 128. So 370 says this: the policy as amended the proposal as amended meets the policy requirement of 35%. That's of course a reference back to SP6. Then it says this: in contrast to the original submission, the revised proposal includes the provision of traditional social rented housing, 116 units of which will be located on the west side within 3 mansion blocks. This amounts to 38% of the affordable, which set against the policy SP6 is below the required 50%. In relation to the east side, the rental levels do not conform to the distribution requirements set out in emerging policy P4. The proposal, and that's what we've just been talking about, reflects GLA grant funding recently confirmed, which has facilitated an increase in the number of social rented units from 74 to 116. So we saw that the switch from social rent equivalent to social rent, which is relevant in one dimension, took place in the shift from 33 to 74. The GLA funding is identified as facilitating an increase in the number of social rented units. Now, this paragraph, and of course it's qualified by the passage I'm going to take you to in a moment, this paragraph says that the GLA funding is recently confirmed. Now, as I said, that is qualified, so we don't rest on that. What we do look at, though, which we'll come to in a moment, is what the addendum said about that. We then have at 389, following further detailed analysis of all that, which I'm not going to grind the court through unless we need to. 389 says this: the above analysis therefore indicates that, subject to consideration of viability, there would be a material conflict with the development plan in respect of the form and mix of the affordable housing offer. However, it is of note that the main improvement that arises from the revised proposal is the provision of social rented accommodation to be provided by the council or an RSL. The 10-year split breakdown is also out of step with the expectations in the emerging policy. So the main improvement is the provision of social rented accommodation. There are then passages dealing with viability, and in particular, for example, paragraph 398 tells us this: officers are satisfied in the light of viability testing outlined above that the applicant's affordable housing offer, coupled with the securing an appropriate review mechanism, see below, represents the maximum reasonable affordable housing provision, taking account of ... Now, in other words, as I indicated much earlier in my submissions, essentially exactly the same thing had been said about the offer as it was on the table in January. And all of this, of course, in the context of the way in which policy 312 of the London Plan and SP6 work, which is recognising that this is, to use the words of 3.12, a negotiation. And the point I've been making throughout, this is not a cut and dry black and white question. So members were told in January this is the best you can get. More emerges in two chunks. You've seen the two chunks, and then they're told again this is the best you can get. So
do you challenge any part of that viability testing as summarised in the previous paragraphs, or do you accept it?
Well, we can't say it's wrong as a matter of law. The claimant doesn't accept the analysis, and it's made more difficult by the fact that the information in the public domain is very limited information. So a great deal of the information behind all of that is not in the public domain. So he's not readily in a position to challenge it, even on its merits. But we don't say it's wrong as a matter of law in the analysis. What we do point to, the point I've made already, is that although at first blush the notion of what's maximum affordable might look to be an objectively ascertainable, cut and dried, repeatable evaluation, actually it's not. Of course, it's a complicated thing that relies on all sorts of assumptions.
But it's been assessed on the basis of a test, of a process of viability testing in the previous paragraphs, which you're not in a position to challenge.
Well, we're not in a position to challenge the judicial review, but equally the point I make is the one I've made already, which briefly make again, if I may, which is that the same conclusion was reached, and in other words, this is the best we can do, when the offer, the affordable housing offer in January was a mere 33 and was a social rented equivalent. So that we say is a reminder that this isn't. It's not that you get to the 33 in January and this is ceiling and any more is impossible, because what we see is that whether through the emergence of possible grants or simply because the developer shifts their position in the negotiation, it can't be ruled out that more is possible, and that's all we need to say about that. So it's the continuing conclusion that we point to. Well, that's 398. You then, on page 132, above paragraph 402, have the process which has been trailed already, which is, as you see in this next paragraph, a standard council requirement of a development of this scale and longevity, which is to recognise that whatever the viability assessment is now might change during the lifetime of the development. So you have a concept of viability review. The 402 says this: in view of the fact that the affordable housing provides a compliant quantum of 35% but has a non-compliant 10-year split, and in line with the Council's Development Viability SPD, a viability review, VR, would be required. This is to ensure that if the economic circumstances of the scheme change in the future, an improved 10-year split can be achieved in order to more closely, if not fully, be compliant with the policy. The detailed requirements of viability reviews will be secured within the Section 106 agreement. So seeking through that mechanism, if it turns out to be possible because the economic circumstances change, a more compliant policy. 403, italicized text, then talks about the time scale of that, the trigger timings of that. I don't think we need to dwell on that. But 404 returns to the point of one of the points of issue here, which is the option of the buy to sell on the west site. In the event that the west site is delivered as open market for sale, the review, in other words, the one that's taking place inevitably already, will need to take into account the policy requirement for a different 10-year split of 50-50 social rented and intermediate. So the policy requirement for 50-50 is back to our old friend SP6. In addition, it should be noted that regardless of whether the west site comes forward as billed for sale, if for any reason the development stalls and ultimately fails to process, the applicants confirm that the social rented units will be delivered. This will be secured with the legal agreement. So that is to be read alongside, clearly, paragraph 365. So 364, 365 and 404 are picking up a combination of circumstances, namely what happens if the development doesn't proceed on time, that's the 10-year point, but alternatively, what happens if the market is rather more buoyant than everybody expected, that's the viability point, but also, as a subset of that, what happens if the developer elects for the buy-to-sell option on the west side. So those things are being contemplated in those paragraphs. And obviously, key to our case is what the court makes of those paragraphs in terms of where they leave officers and with what scope of delegation. You then have, and there's obviously a lot more in this report that I'm not taking you to, but I don't think it's key at this stage at least. We then have two addendum reports, the first of which is at page 244 of your bundle.
Yes.
Within this, if you go to page 246, not in any sense describing as a correction, but shedding more light, paragraph 11 says this: viability review of the applicant's revised offer. GBA, which is advising the council on the viability of the proposed development, has confirmed that the applicant's revised affordable housing offer, which includes an agreement in principle for grant funding from the GLA, is the maximum that the development can reasonably support. GLA has also confirmed that the provision of grant funding would not increase the developer's profit in comparison with the earlier affordable housing offer, which included 74 social rented units. So the language describing the status of the grant has softened to some extent. It's now described as agreement in principle, but it's clearly seen by the council's advisors GBA as underpinning, that proposal is seen as underpinning the increase from 74 now to 116, and that point is emphasised by the fact that receipt of that grant doesn't increase the developer's profit. The implication being this money is being used to fund the increase, the availability of money, in principle availability, is funding that uplift. All perfectly proper and perfectly as contemplated, as I showed you by the much earlier letter, which says if we get grant funding, we can increase our offer. Within that same addendum report, then on page 248, paragraphs 22 and 23, so this is officers responding to further consultation responses. It's a little bit confusing. If I just step to one side for a moment. There are various passages in the overall report which refer to consultation responses, and of course some of those consultation responses are responding at earlier stages of the evolution of the development. So it's a little bit confusing to unpick them if one needs to. But this is a feedback to the members, a quite proper feedback to the members, and a response from officers on representations made by the 35% campaign, which, as you will have seen, is the organisation with which the claimant, the appellant, is associated. And so paragraph 22, in the bullet point summarising what the 35% campaign have said, the fourth bullet point says this: request confirmation that the GLA funding would equate to 11.24 million. Request confirmation that the latest affordable housing officer would be delivered even if grant funding could not be secured. Request confirmation that social rented units would have secure tenancies if managed by a housing association. And then
Just
23.
There, 35% campaign knew that the funding wasn't guaranteed. That's why they were asking for confirmation, because they knew it may not come through.
That's right, because it's identified as being agreed in principle.
Yeah,
so, in
they knew it. They weren't misled. I mean, I know we're looking at the officers and the councillors, but the 35 campaign were alive to the possibility that the grant may not come through.
I'm not sure what's my lord referring to in that regard.
Well, they wouldn't have asked whether it would be delivered even if the grant funding could not be secured. They must have known the grant funding wasn't guaranteed.
Absolutely not guaranteed,
Yeah.
but that's not for a second the same as saying agreed in principle. There's degrees of confidence around all of these things, and that's the important question.
But let's have a neutral phrase. Well, let's have an accurate phrase. Was not legally binding. The grant of funding was not legally fixed.
That's correct. They were contemplating that possibility because what's being said is agreed in principle, and agreed in principle always conveys a degree of risk. So they knew that
There's not a degree of risk. They knew that it wasn't legally binding. They knew that the developer could not insist upon the provision of funding legally.
That's absolutely right. But the point I'm making, the only point I'm making, and I may not be making it very clearly, is that there's a difference between, on a spectrum, if you like, legally binding, and everybody knows it's not legally binding, and agreed in principle, which is a step away from legally binding, but very close to it, in a sense that it conveys to the reader, we say, and to the council member, more importantly, we say, a sense of likelihood.
What were your clients asking for confirmation of here?
Well, it's the character. Even if grant funding could not be secured, will you deliver the social housing units?
Yeah. What were they asking? What were they asking, and why were they asking it?
Well, I'm not going to take instructions on the second part of that, my lord. But the implication of the question is to make clear that if, insofar as there's a doubt around in principle agreement, that's not going to imperil the delivery of the 116 houses. And when we come to the way the judge dealt with this, the judge concludes, and we don't take issue with this. It just misses the point. He concludes that members were not misled as to whether this quantum of housing would be delivered. They were not misled about whether this quantum of housing would be delivered, in a sense, thanks to this exchange that we're seeing here. But that's not the point that we were pointing to, and I'll take you back, if we need to our skeleton argument in the court below. It wasn't uncertainty about whether this quantum would be delivered. It was uncertainty about the status of the grant, which went, as I'll explain in due course, to the question of whether this was the maximum affordable amount that could be achieved, or whether more might be achieved. So it's not doubt about whether the 116 is in the bag, because this exchange that we're partway through on 248 makes that clear. So the judge answers the question, which in a sense was never in dispute.
Well, we look at the response of the officer, paragraph 23.
Absolutely. Yes. The response of the officer, paragraph 23, These comments are largely considered in the affordable housing section of the report. We've seen that. There's an agreement in principle for grant funding, 11.24 million. That's the number question that's being asked towards affordable housing. And the applicant has committed to providing the level of affordable housing set out in the offer, and including 116 social rented units, and this would be secured in the Section 106 agreement. That's all absolutely correct. There's no doubt, and nobody's in any doubt at all, that the 116 will be secured, come what may on the grant. The question, and this is the point the judge didn't deal with, is the nature of the uncertainty around the grant and the implications of that.
As I understand it, you seem to be saying they might have got 116 without a grant. So, why not go back and say you can afford 116 in any event? We want a bit more, please. But that surely is a matter for them. This is the third time of asking. Each time they're told that's it. They ask for a bit more, they get a bit more. But isn't it ultimately up to the councillors to decide, right, this is where we think the tent should be fixed?
Absolutely right, my lords. My lords absolutely got it, and landed in exactly the right place for our submissions. The question is that when the councillors undertake that evaluation, as they needed to do, what is their understanding of the certainty of the grant, the confidence level around the grant, and about what risk the developer's taking?
They know that the grant is not legally binding. They know that the developer can't insist on it, and they know the developer is running the risk because if they don't get it, they're going to have to build the 116. And that, you've admitted, was something that they weren't misled on. And thereafter, it's poker. Do you twist or stick?
Right, my lord, I don't want to be drawn into the sort of dangerous territory analogies, but it is a negotiation, and what we say, and the court may not accept the submission, but what we say is that there's a difference, a material difference between, in that game of poker, if I can pick up that characterisation with trepidation, councillors understanding on the one hand, they've been disabused of the notion that this is certain, they've correctly been disabused of that notion, but they are still being told that it's agreed in principle. And that is not the case. The position is that all that's being said is that the developer is entitled to make an application against a set of criteria, and therefore it's in the very earliest stages of any kind of process around that. And what we say, and as I say, the court may not accept this submission, but our submission is that there is a material difference in the minds of the councillors, or potentially a material difference, when it comes to that negotiation, that twist or stick, whatever it may be. And my lord's exactly right. I wouldn't have put it quite the way that the Lord Justice Lewis put it, but the proposition is, if you can, in this game of, game's the wrong word, in this process of increasing offers and increasing numbers and so on, if you can certainly deliver us 116, then you can potentially deliver us more. And there's a difference, we say, in that evaluation between grant 11.2 million, which is in principle agreed, and what turns out to be the case, which is 11.2 million is an aspiration. And the attitude of councillors in that situation, we say, might have been different. And that's all we need to say for these purposes. And we say, to that extent, we'll come to the submission, but I'm having to trail it now, obviously. The report was either, you can characterise the report as misleading, or you can characterise the members as having proceeded on the basis of a mistake of fact. But either way round, we say the impact is potentially material, and the way the judge dealt with that, which is the Section 31 argument, we say was not an appropriate response. So don't shy away from any of that. My Lord Justice Lewis, in a sense, not quite the characterisation of the words I would have used, but in the characterisation of the overall position is absolutely right. In terms of the process, you then have the council's resolution to grant.
We're leaving the addendum now. We're leaving the addendum now.
We're leaving the addendum. Actually, I should probably show you the second addendum just for complete. Yep. Addendum number 2.
It's 254.
But 256 is the paragraph 14. Further objection to the 35% campaign. Six bullets down. As grant funding has been secured, there will be less risk for the developer, therefore there's less need to rely on a viability review to improve the 10-year split. And then the officer response. So their understanding is firmed up by what we've seen. Officer response at the foot of the page. Last few words on the page. Addendum report 1 considers viability for a build to sell scenario on the west site, which will be a fallback position in any event, and the social rented units would be protected. The applicant's proposal and clear intention is to develop the west site for PRS, as indicated a possible unlikely scenario where we can develop a build for sale. This will trigger a slightly different affordable housing requirement, we've seen that, SP6. The Section 106 legal agreement will set out how this will be addressed, should it arise, and ensure that the requisite affordable housing provision will be secured. The committee is entitled to consider the application on that basis. So it's very clearly put to them that you're considering it on the basis of that package of things which interrelate the various elements we're talking about. You then have in the next document the minutes, starting at page 260. And the reference to the agenda pack, which my Lord Justice Lindblom has drawn my attention to, and we will investigate. Then item 6, shopping centre, etc. And then the resolution. Resolve 1, planning permission be granted subject to conditions, and the applicant entering into an appropriate legal agreement, and then subject to various reference processes. And then paragraph 4, in the event the requirements are not met by a cut-off date, the Director of Planning be authorised to refuse planning permission if appropriate for the reasons set out in paragraph 757 of the report. That's a reference. 757 gave to the Director, at page 194, that the explanation for a refusal in the event of an unsatisfactory Section 106 agreement would be by reference to the failure to ensure adequate provision of affordable housing. So that was seen as being the key component of the Section 106 agreement and its success or failure, as in the contemplated reason for refusal in the event that there wasn't successful negotiations. And so
you passed over paragraph 3 of the resolution. I don't know what part that plays, if any, in your argument. The reference there is to the main reasons and considerations on which the Planning Committee's decision is based are as set out in the report. How does that relate, if at all, to the concept of an appropriate legal agreement? Are you going to come on to deal with that?
But my Lord, I am. We say, I think in a sense there's no dispute about this, either the parties or the judge, that the resolution and the appropriate legal agreement is not simply read in the abstract. No. It's read in the context of what was said in the officer's report. And paragraph 3 of the resolution is an explicit link back, where one normally might infer that. I mean, we're going to come to the Lord's decision in Mansell, but in the absence of that, one would infer that. But here it's made explicit, the main reasons and considerations. So if my Lord is picking up on the distinction potentially between reasons and considerations,
no, I wasn't actually, because I've discerned this to be common ground between the three parties here. The approach to the committee report, at least to this degree, is accepted, that one has to read the resolution with the report, at least to discern the main reasons and considerations on which the decision was based. And that, of course, encompasses the concept of an appropriate legal agreement, and one is seeking to understand what that means and what latitude there was in that concept. But I think, from the skeleton arguments, that all seems to be, that much at least seems to be common ground.
Well, I think that's right. I think the distinction, and it's seen in the way the judge analyses it, is what legal approach one takes to the report for these purposes.
Yeah, I mean, in Mansell, I've referred to Lord Justice Lewison's judgment in, I think, in Palmer, was it Palmer? Where he makes the general observation that one can generally infer that when the members made a decision in accordance with the recommendation made to them, that the reasons for it would normally be as indicated in the officer's report recommending that outcome, or something to that effect.
Well, that's
This-
right.
Yeah, I think it's Palmer. But this is the case, as you say, of an explicit connection.
Well, that's right.
Yeah. All right. No, sorry. Well, maybe I needn't have intervened, but I just.
No, I think it's helpful that, but I don't think there's any I don't think that the connection is if anything reinforced by it being explicit. But I don't think there's no suggestion from any of the parties that there isn't the requisite connection. It's simply what one makes of the officer's report for those purposes.
Indeed. Yes, that's exactly right.
So that was the resolution in July. What you then have in the intervening proof for the grant of plan permission, let me just pick those points up in if I may. You first of all have in supplementary bundle at tab 3, you have the letter, the contents of which I've as it were foreshadowed. So this is a letter explaining the situation with the grant proposal, the grant application. You've only got the front page, but what's on the second page is essentially just the signature. So they're not materially missing any text, I don't think. What the letter then explains is the third paragraph down. The letter from my team, which is the one, it's the letter you've seen, 14th of June letter, does not constitute a funding agreement, nor does it commit the GLA to make funding available in the future. The purpose of the letter was to confirm receipt of T3, that's the applicant's residential application to become a GLA investment partner, and outline details of the conditions under which grant funding may be available to T3 residential to support delivery of affordable housing at Oakham Castle. The main conditions which T3 residential are required to satisfy to access grant funding under the terms of both the GLA and the social housing regulator are as follows. And there's a whole series of prerequisites, including submission of a bid and compliance with a set of criteria from the mayor. But the point we draw from this is that far from this being agreement in principle to the funding, this is merely confirmation that you are eligible to apply and telling you the process and the criteria which you'll have to go through and meet respectively if you're going to do it. So what we say is that there is a potential material difference in the different description, the characterisation to members of saying in principle, and the characterisation that actually emerges from the underlying materials that they didn't have, as to the status of that grant. And in the situation contemplated by my Lord Lord Justice Lewis, in other words, we are negotiating the quantum of housing. If we, the members, know that the 116 is guaranteed, but it's not being underpinned by an in-principle agreement, it's merely being underpinned by an eligibility to apply situation, that is a difference which might, and that's all we need for these purposes, have led members to say, well, actually, we're not going to twist or stick at this point. We're going to, maybe the wrong way around, we are going to hold out for more. So that's the point at which the judge, through the prism of Section 31 at the invitation of the defendant and interested party, we say went wrong in principle because he embarked on an evaluation effectively of the planning merits or speculation as to the planning process that would then have followed. And we say that was not any proper part of the Section 31 exercise. The other thing that happened in this intervening period heading up to the Section 106 agreement was a series of exchanges with the developer, very obviously, but these are picked up by the judge. If I can just go back to the judgment, he picks these up helpfully at paragraphs 25 and following. So he explains in paragraph 25 that a draft was circulated for consultation with ward councillors. That was part of the requirements of the resolution. But just pausing there for a second, that process of circulation of ward councillors, we say there's no basis to say that could in some way expand or change the nature of the scope of delegation that was given to officers, merely a recognition that they should exercise that delegation discretion in the light of consulting with the relevant ward members. And then he says this: for the present purpose, it's necessary to focus on the negotiations and agreements which were reached in respect to the affordable housing provisions, and in particular giving effect to paragraphs 364, 365 and 401 of the officer's report, which address the issue of ensuring affordable housing and so on. But we say that that characterisation was entirely correct. That the process here was, amongst other things, and obviously there was a lot more in play as well, about giving effect to paragraphs 364, 365 and 401. But what he then picks up in paragraphs 26 and 27 is exchange of emails that obviously the full text of this was before the judge, who pulls out the relevant passages between what he calls the defendant's officer, Ms. Hussein, and the developer's solicitors. I think he somewhat understates Ms. Hussein's position, because she's not just any old officer, she's a solicitor in the council's legal department, and she engages in email exchanges with the developer in the course of this negotiating the Section 106 agreement, and we say Ms. Hussein gets it absolutely right in terms of the implications of, amongst other things, paragraph 364 of the officer's report. She says this, put on page 108, following Monday's meeting, the council reviewed the planning committee report and addendum from the 3rd of July in order to ascertain what the Section 106 agreement can and should secure. The following matters in respect to the social rented units and the LUL issue can therefore be the council's only position on this matter, and any departure from the position will require the matter to go back to the planning committee for fresh consideration. And then she sets out what was then being contemplated in terms of the scenarios for the non-delivery of the west site.
Sorry, just pause. The page reference. I beg your pardon. The page reference.
Page 108. It's paragraph 26 of the judgment. I'm sorry, took it too quickly.
Oh, I thought you were taking us back to the original correspondence. No, well, I've got the judgment. Yes, I don't need to look at the original.
I don't think so.
No.
So she rightly, this is the top of 109 in the judgment, says this could be the council's only position on the matter. Any departure has to go back to the committee. We say that's absolutely right. And then in a number of paragraphs below, paragraph 2, the foot of that quote, failure to secure the transfer of the social rented units in the above scenarios will put the council in breach of paragraphs 364, 365 and 404 of the officer's report, and will therefore require the council, that must be the officers, to refer the matter back to the planning committee, or failing that would run the risk of a potential judicial review challenge. The council therefore requires your client to accept an obligation to transfer land to the council, together with the construction and demolition costs in the above 4 scenarios. Drafting has been inserted into the Section 106 agreement to deal with the non-residential units which form part of the same block. So we say she is entirely right in her understanding as to the delegation implications of those paragraphs, and that the process, if the developer wants to hold out for something different, entitled obviously to do that, she says this, we have to go back to the council.
Can I just understand, this is her view. You've got no problems with it up until the end of 1, because she has set out the situation where the transfer of land is required. There are 4 of those, and she says that failure to secure the social rented units would put the council in breach, and that's fine. That doesn't tell us anything about the scope of any Section 106 agreement. And then she sets out her view that because of the above, the council therefore requires your client to accept an obligation. But if somebody comes back and says, well, no, actually, when you analyse the delegation more carefully, it's a slightly more nuanced and complex process than that. Why is it any more than that? I mean, the ultimate thing is not what this solicitor thought when she read it first of all. The ultimate thing surely is the resolution read in the context of the report.
Well, and I thought what my lord was going to go on to say, which is obviously the right answer, is ultimately it's a question of the court.
But this is all a negotiation, as you said.
My lord, yes, and what we see in a moment is that, as you're saying, is clearly overridden by colleagues in the council's team. I'm only drawing attention to what she explains to identify the way in which and Obviously, it's not determinative because the issue is one for the court in the end.
But it's even a document that comes after the resolution. You can't possibly use a later letter, can you, to try and interpret the scope of the delegation?
Well, maybe I'm not seeking to do any of those things.
What's the relevance of it then in terms of the issue that this court out? We have to decide what the resolution means. It's common ground that we have to read that against the background of the report. Why is the view of this officer any more interesting than the solicitor from the interested party's solicitor as to what the delegation means? That's ultimately what this court has got to decide, isn't it?
That's of course right, Lord. I'm sorry if I've taken time with the court on a distraction. Obviously, the drafts go back and forwards. Obviously, Ms. Hussein is her view doesn't prevail. There's then a brief update report in January, which I think is seen by the Director of Planning as part of his exercise of his delegated powers, and then he exercises those delegated powers in the context of executing the Section 106 agreement and the grant of planning permission. The grant of planning permission itself, let's just see where that's recorded. The grant of planning permission is in Core Bundle 2, Tab 1, and the reference to Mr. Bevan is on page within that. It's a document with appendices. The document starts at 355. And Mr. Bevan features on page 388 at the end of the section dealing with conditions. And what you then have in the next tab is the associated Section 106 agreement. And it has a series of definitions. We've seen a little bit of that already, starting at page 402. As presented here, at 402, it has the definition of additional affordable housing that was then substituted by the deed of variation that we'll come to in a moment. At 440, just to give you the structure of the overall agreement, page 440, paragraph 4, or section 4, is a heading obligations of the developer, and it's here that the developer undertakes to perform the obligations set out in the schedule. We are most particularly, for these purposes, concerned with Schedule 3, which deals with the west side, That starts, just in terms of navigating the document, at page 544. It has 3 parts to it. We're concerned with parts 1 and 3. Within part 1, we start at page 546, section 2, or paragraph 2. There's an in perpetuity protection in relation to the social rented units. And then 3, transfer of land for social rented units. And 3.1, paragraphs 3.2 to 3.9 will only apply in the event that either the west site's not been substantially commenced within 10 years following the development being implemented on the east site, or following substantial commencement of the west site, there is a continuous period of inactivity on the west site for more than 6 consecutive months. So they are picking up in trigger terms the possibility that with this 10 or so year development, where the social, the affordable housing component is backloaded in the development and therefore in the timescale, there is a possibility that the affordable housing wouldn't be delivered because the whole development wouldn't be delivered or wouldn't be delivered in this timescale. So this is quite properly picking up, as contemplated by the officer's report, the trigger for a mechanism to secure delivery of the social rented housing. So this is here the 116, not any uplift on that. There's then a series of exchanges between the developer and the council set out in 3.2 and 3.4. And then the developer is given the opportunity to elect for one of three options, 1, 2 and 3, and 351, 352 and 353. And the simple point, and it is a simple point in the end, is that we say those options are ultra vires or not intra vires the officer's scope of delegation in relation to the Section 106 agreement, because of the effect of paragraph 364 of the officer's report read in context. And the court's either with us or against us on that. I'll come back to make the submissions of it on it in due course, but the simple proposition is that paragraph 364, uses the language of stipulate and tells members, and then members proceed on the basis of this proposition, that the Section 106 will stipulate transfer of land and money. I'll come back to the details of the wording in due course, and it's money sufficient to do the development. And the simple point is that that's not what any of these options do, that they transfer in various different combinations, and in my case doesn't depend on the detail of the combinations, and what they transfer is assets. And it may well be, not part of the case in this appeal, it may be that those assets are of equivalent value, but we say members specifically resolved this process on the basis of not just the transfer of the land, but also the money to enable the development to go ahead.
I thought option 2 did involve the payment of money. Isn't option 2 land and the net construction costs?
But if you grind through, I don't think it's any part of Mr. Harris's or Mr. Konitsky's case. If you grind through what that means, that isn't the same as the money to do the development in a way that's contemplated by 364.
Well, that's the whole point. You say land and sum of money sufficient for construction and completement. You say includes upfront costs, although it's not actually referred to, and you've got a view of it means all the construction costs. But if you look at sufficient, and if it's slightly different, why can't it include the land and the net costs, the net construction costs, to ensure construction and completion of the social rented units?
Well, my lord, because it's what the judge used the expression. I don't quite know where he got the expression from. Front funded, I think was the expression he used. In a situation where local authorities are not awash with cash and have borrowing restrictions on them, that there is all the difference in the world between being given an asset against which you may or may not be able to borrow or realise value, and being able to have the cash to do the development. What's being and again, the important element here is that, to use the language of the report, members, or the report which members adopted, stipulated what that should look like. It need not have done that. It could have said something.
Sorry, this is just a factual point. It's not a gloss, it's a factual point. I thought you said that there was no money involved in any of options 2 or 3, and it's a simple factual point. And then it's a question as to whether or not the factual point does or doesn't fall within the delegation. I thought there was going to be under option 2 the transfer of land and the payment of money said to equal the net social rented construction costs, 10% on notice of 10% on grant, 50% within 20 working days of the council agreeing a build contract, and 40% within a year. That's what's at page 528. So I thought option 2 was land plus money, and there may or may not be arguments as to whether or not that meets 364. But it's not correct, is it, to say there's no money, or have I simply misunderstood?
It's not suggested that is funds which will enable the council, without borrowing against the asset, to construct the affordable housing which is being protected by this mechanism.
Yeah, so that's an argument as to whether or not it's sufficient for construction and completion. But I'm trying to pick a factual matter, so I've understood it. I understood you to say there was no money, full stop, next sentence.
Apologies,
I'm saying to you that's not a correct full stop, next sentence.
Apologies if I misspoke. The issue here is whether the council is being given, as the 364 stipulated would be the case, sufficient funds for them to enable them to do this job with the transfer of the land and nothing else. And there's no that is the what's the right word, the watershed question.
So option 2 is land plus net costs at particular times. Option 3 is land £1, and it's assumed that the assets equal the amount of money that would otherwise be available, and it's whether either or both of those are within 364, because if one of them isn't, we might strike that one out.
Yes, I'm not sure I'm totally following my lord's speedy delivery.
Just to go through it again, there's two options here, option 2 and option 3. Option 2 is transfer of land plus net costs at particular dates. Question is, does that fall within the 364 paragraph? And we'll have arguments in due course about that. The next question is, does it fall within option 3? That, as I understand it, was transfer of land, no transfer of money, say for £1, because the land transfer, the non-residential parts, were thought to be equivalent in value to the amount of money. And the question is whether that falls within 364. If one or both of those are ultra vires, that is a good way towards the end of the case. If it's only option 3 that's ultra vires, then I don't see why we can't strike out option 3, and then the councillor would have either option 1.
My Lord, can I come back to that in due course, having taken the opportunity over lunch, as I will do, to refresh my memory as to why it is, and we went through all this before the judge, and I don't recall it being an issue then or now, as to why the reference to net SR construction costs, once that definition is understood through the trail of definitions in this document, doesn't do what on the face of it would appear to achieve, which I think is my Lord's point, and I'm very happy to deal with that.
But it seems to involve a transfer of cash, which seems to be the first thing, and then you say it's not going to be a sufficient amount of cash for what you understand 364 to mean, which is the total construction costs.
Yeah, well, that's correct. That's correct, and what we simply say at the headline point is, and my Lord's right to distinguish the different limbs of it. The headline point simply is that 364 is clear in saying sufficient, and it's talking about sufficient cash.
Is it? Does the word sufficient qualify the sum of money?
In 364.
Or does it qualify? Does it qualify the whole of the consideration, if that's the right word? Land and sum of money sufficient.
You're looking at 364.
I am.
364.
Does the phrase sufficient for construction and completion qualify the words sum of money or the words land and sum of money?
We obviously say it qualifies the sum of money, because if you take out the words and sum of money and just read a sentence that says the land sufficient for construction, that wouldn't make sense as a matter of language. So we say, as a matter of understanding of that paragraph, the sufficiency qualification is in relation to the sum of money.
Well, surely it could be both, couldn't it? If you don't have enough land, you can't construct the units that you need.
But it could be both, but it's certainly not only. That's a fair point, my Lord. I haven't got it that way. That's exactly. If you've got given enough land or enough money, but it certainly needs to be enough money. I think my Lord's right.
But then, of course, it becomes a different exercise, as my Lord Justice Baker was saying, because what you're looking at is land and money for what? Sufficient for construction and completion. And then you're beginning to read inwards, aren't you, when you're saying, oh, well, we actually mean the whole of the construction cost, and we mean the whole of that up front.
Well, the court may be against us on the point, but that's what we say this paragraph means. Land and a sum of money is sufficient for the construction. And if we're looking for a sum of money, not some other asset or consideration that could be borrowed against or whatever. If it's got to be a sum of money sufficient for the construction, as well as, to take my Lord Justice Lindblom's point, sufficient land, which needs to go ahead, then it's got to be sufficient to do the construction, and that's.
If we talk about this as an instrument of delegation, which the other side say it's not, then you've got to look at it carefully. It's not the land and the sum of money sufficient for construction. You know, it becomes altogether looser when you start leaving out definite articles and having adjectives like sufficient tossed in.
Well, I mean, in the sense that well, just to pick up on that particular component of it, the word the missing if there's a missing a word, a sum or the sum of money, we would say nothing turns on that. So we're coming a bit to the exercise of construction, but
it's directed, isn't it, at the delivery? I mean, let's look at the end of the sentence, without being drawn. None of us wants to get drawn into an excessive parsing of a sentence in a committee report. We all know the dangers in doing that. So that's where we come in. Let's just focus on the concept of delivery, which is the verb used at the end of the sentence, to deliver the social rented units. That's what is being focused on.
That's absolutely right.
Well, if I may just go on. Question might be then whether the provisions of the Section 106 agreement, as ultimately entered into, effectively secure the delivery of the social rented units as contemplated by paragraph 364 of the report. And when you read those options, can it then be understood that that is what the Section 106 obligation is actually doing?
But
that might be described as the pragmatic way of looking at things.
Sort of drawing the adjective, but it's undoubtedly correct that 364 is identifying something, quotes, to deliver the social rented units.
Yeah.
Our case is very simply that it doesn't just say do whatever you want to deliver the social rented units. It's much more specific than that. And in particular, it specifies what, in terms of financing that activity, is a material component, namely that you've got to have the land and, we say, sufficient money, not just assets against which you could borrow or assets which you could realise or whatever it might be.
But why should the land include the non-residential floor space? Or does it? Do you accept the land does include? Do you accept the land does include the non-residential floor space?
Indeed. There's no reason why it shouldn't at all, because it simply says that land, if my Lord Justice Lindbaum's correct point, it's got to be sufficient land. There's nothing to preclude additional land being transferred at all. None of that precludes additional land being transferred. It's got to be sufficient land. The question that doesn't answer, though, is how is the development of these units on that land, even if it's more land, going to be financed? And the committee report is quite clear on that point.
Surely the transfer of the non-residential floor space at nil value represents an asset, a part of the land, an asset, which is going to contribute to the completion of the social rented units, to deliver the social rented units.
That may be so, my Lord, but
well, in that case, why doesn't option 3, and I would suggest option 2 also, comply with paragraph 364?
Because of the distinction between providing the council with an asset and providing the council with money in the context of the local authority having amongst other things constraints about the way it borrows and so on. And the simple point is, in a sense, we don't think we need to debate that point, because this is a legal, in this regard, this is a legal instrument. It's conveying delegation, a scope of delegation. It has to be understood.
Could it have been possible? Would it have been possible to transfer only the residential floor space, or was it inevitably the case that if the land was transferred, it would include the non-residential floor space?
I would have to just check that. I mean, it's not a detail that's teased out at this point in the process. I think it may be that.
What point in the process?
In the committee report point in the process.
Well, doesn't that illustrate the dangers of the process you're undertaking here of applying too literal a narrow interpretation of paragraph 364?
but look, that sort of argument is featured in the judge's reasoning on the further component, which is the bill to sell fallback position, where the judge identifies that one of the reasons that officers negotiated social rent equivalent as opposed to social rent was because of what were called by the developer and the council practical considerations, which arose in the negotiation of the Section 106 agreement. And we say, well, those were not matters that were contemplated before the committee, not part of what was the committee considered. They were potential material changes if they were of the nature that's being identified, potential material changes, which meant that whether you call it a scope of delegation question or a material considerations question, and I'll come back to that in a little bit, meant that that would have triggered a need for it to go back to the committee, because it's now being said, well, we can't do what you sent us away to do, or put it the other way around, issues have arisen which we hadn't contemplated. Those aren't a basis, or that development is not a basis, we say, to change the scope of the delegation.
But it may be the context, though, in which the delegation is to be understood. Were the officers saying there will be one way that this will happen if after 10 years it's not built, and that way is we will get the land, but only the land, the units, and money to build the cost. So if in fact the world is more complicated and you can't do it that way, and we need a more nuanced approach, we'll have to come back to you. Was that what they were doing? Or in context, were they saying, we recognise there's a problem, if this isn't built within 10 years, we've got to find a way of filling that, and we'll make sure there's delivery, and we'll make sure you get the land with the wherewithal for the units to be delivered. And we'll make sure that the agreement achieves the land and the wherewithal to have the units delivered. That's the whole question. One can't start off by assuming the answer to the question. You've got to look at the question.
Well, I don't shy away from that at all. That was absolutely right. And of course, we readily accept, it doesn't matter what Ms. Hussain thought, it's a matter for the court to decide on the legal effect of all of those things. But that question, it is in a sense, it seems surprising, but it does appear to be a novel question of law, because I don't think any of the parties have turned up any authority on the point, which is perhaps surprising given the frequency with which, for large developments, or indeed almost anything involving a Section 106 agreement, that there will be this same structure of a recommendation and a delegation, a negotiation with Section 106, and so on. That's absolutely standard for any development which requires a Section 106 agreement, as the court well knows.
Well, what was the purpose in the sentence of 364?
The purpose of 364 is to ensure delivery of the social rented units, the 116, and to specify the mechanism by which that was to happen.
Well, it was to ensure the delivery of the social units, given the fact that they were all located in the west site, which wasn't going to be built for 10 years.
That's right, yeah.
So what was required here in the agreement was a mechanism by which that could be achieved.
Absolutely, but not just, and at risk of repeating myself, not just any mechanism, because this report and members' resolution on the basis of it could have proceeded without any consideration whatsoever of how that would be done. It could simply have referred to the Section 106 agreement will ensure delivery of the 116 social rented houses, and then there would be no argument about it. If it had focused only on the principle and the outcome of delivery, that would have been different. But we say that the members have to be taken to have given weight to, and the court, in understanding what in the end is a legal instrument, has to give weight to what's expressed in this paragraph. We can't wish it away, and that's why.
No, sorry, I didn't want to interrupt you. Do finish.
No, I think I've finished.
Yeah. Just let me. Don't respond now. We're heading towards 1 o'clock at the moment, and you may want to reflect on the question I'm going to ask you. But I wonder whether the one way of putting this conundrum might be to consider whether given the scope of the delegation under the resolution, the officers conducting the negotiation after that could rationally take the options presented in the draft Section 106 obligation as an effective means of securing the delivery of the social rented units, incorporating to the extent those options did the transfer of land and or money. You can see everyone writing that down, but that wasn't necessarily a precise formulation, but it's perhaps one way of testing the point, because at the end of it all, as I think is common ground, certainly in the light of the response you gave just now, Mr. Wolfe, to my Lord Lord Justice Lewis, this is about delivery. This is about delivering the social rented units and securing that objective. That's the primary purpose. The primary purpose is not of itself the transfer of land and or money, it might be said. So I wonder whether my formulation might come close to capturing the really essential point. Just a thought.
Well, I will come back to that after lunch. But if I could add as a sort of last comment, perhaps before we break, the point about section, the paragraph 364,
yeah,
is that the reference to sum of money sufficient and so on is all in a sentence which is entirely talking about what the Section 106 agreement would stipulate. So this is absolutely tied to the legal mechanism which will be used in order to secure the delivery. So this is the point's often made against me. You have to read these things as in the round. You have to read them in a whole, and that paragraph is dealing with the trigger situation of the West Side not coming forward, and it's dealing with the legal consequence, which is to be secured through the Section 106 agreement, which is to stipulate. So this isn't just a paragraph, any old paragraph, which says we will deliver the social rented houses. It's a paragraph which spells out how that's going to happen.
So do you say that it was attempting to formulate a covenant when it used the verb stipulate? That paragraph.
You mean an agreement element of the Section 106 agreement?
Well, I mean, the word stipulate, it's a lawyerly word, isn't it, when we think of it?
Yes.
Does your submission go so far as to say to us that we should read paragraph 364 as indicating the form of a legal commitment in the form of a covenant, that is, in a Section 106 obligation? I'm
not sure about the word covenant, but an obligation in Section 106, yes, absolutely, that's the case.
Yeah.
Because
covenant's a lawyerly word too, and it's used in the context of agreements between parties.
Yes, but the word stipulates, I don't think it needs to be a lawyerly word. Covenant is definitely a lawyerly word.
Yeah.
Stipulate is an ordinary word of the English language that wouldn't.
All right, well, never mind whether I'm being too lawyerly. Just if you like, the substance of the point. Are you saying that paragraph 364 can be taken as being an indication of the form in which the obligation would express this commitment?
Absolutely, because, and the reason that's the case is because this is underpinning, in this sense, I'm trying to choose my words carefully, the scope of the officer's delegation in negotiating the Section 106 agreement. So across a whole swathe of things, indeed most things, nothing in particular was said to constrain them. And they were given wide delegation under the resolution that we've seen. In the particular regards which we're focusing on, which, as it happens, are the regards of which, as you know, are concern of my client and others, the officer's report didn't do that. It descended into something much more, my word, specific. And in 364, it did something which I don't, which is very particular, which we say members would have understood in the way we describe it, which is this isn't just giving officers an opportunity to go away and, in their discretion, evaluate a mechanism to deliver up social rented units. It's telling them, in a particular regard, how that is constrained. Now, whether that was a good thing or a bad thing, whether the court agrees or disagrees with it, whether the court thinks it matters, that mechanism matters, in a sense of cash or not cash, we say it's neither here nor there. What matters is that that was the scope of their delegation. And
I
that's,
just wonder if a councillor had said, when you say, officer, a sum of money is sufficient, how much? I wonder whether the officer might have said, oh, well, that all depends.
Well, probably right, because it needs to be calculated at the time. We couldn't specify X pounds at the point of delivering the Section 106 agreement because you're by definition 10 years or so away from doing this. So the sufficiency has to be a formula of some sort. But the point is, it's not just sufficient, but it's a sum of money. It's not an asset that can be whether or not the asset's as valuable as is required as needed is a separate question. We can't get away from the fact that this is what councillors said the Section 106 agreement would stipulate. And the question is, what's the legal effect of that? Is that a convenient moment?
It is indeed. Thank you. We've asked you a good many questions, Mr. Wolf, but are you roughly still on track?
I'm in the end, as often happens, the questions have taken me ahead of myself, so not as far behind as you might think.
I see. Well, thank you very much. Fine. Well, we'll come back at 2:05 and resume then. Thank you very much. 2:05.